David, you can begin.
Sorry. Here I go. Can you hear me now? All right. It's always good to start a recording with "Can you hear me now?" Uh, this is a topic that I've been interested in for a long time, and I'm glad that Aviva gave me the chance to give the excuse to do the research. My practice is primarily intellectual property law and internet law and computer law, so this is an issue that I address in practice from time to time. And I understand where the issues are coming from. And I'm glad that I had the chance. But we're going to start first with my golf game. My golf game is to be charitable mediocre, which means I do not buy brand new golf balls because they get lost too quickly. I go to a website called lostgolfballs.com. This is not a commercial for them, but if you are like me, it's not a bad idea. And I buy mint condition golf balls for about 20% of the price of brand new golf balls. And I mention that because of the next slide. The next slide is from the Times of Israel, which I am a blogger on and I write on regularly. And I am on all the time. And it happens to have nothing to do with lost golf balls, whatever. But I went to lostgolfballs.com to look to buy some new golf balls or some new used golf balls. And every website I go to, including the Times of Israel, which has nothing whatsoever to do with golf, sends me ads for lostgolfballs.com. The point being that that whether it's Chrome or Internet Explorer or whatever engine you're using, your search patterns, the websites you visit are sticky and maintained by the algorithms. They keep track of what it is you're looking at and what you do and your behavior on the internet. That might seem a bit creepy, but is what the algorithm, in fact, it does seem a bit creepy after all. If I went to the Wall Street Journal or the New York Times, this same ad would pop up. It doesn't matter which websites I go to, this ad pops up. And I mentioned that, that's pretty benign, right? And it's kind of annoying in a lot of ways, especially when some of the ads, this is a static one, this particular one will have a flash that will pop up to show me the golf balls and remind me that I really need to buy some. And so the stickiness is something that's going on and something that we all deal with. If you're buying shirts and you go to or shoes, it's going to show up. And it's really kind of silly from the advertiser's perspective, because if I already bought them, I don't need the ad to buy some more. And if I didn't already buy them, I'm not going back to the website to buy them. And that it's kind of a silly from their perspective, from a financial perspective, but it must work because they're doing it. But it's pretty benign, right? It's just a little bit bothersome, and it's the head of an article on what's going on in Israel right now in Lebanon, and yet it has ads for lostgolfballs.com. But it's not always so benign, and that's the problem. So this is an article from June 1st of 2026, in which, and I highly recommend this article, by the way, in which basically a family was destroyed by their 14-year-old son, who is on the autism spectrum. I recommend the article to you for the details, but basically he went on the internet, became radical, he converted to Islam, became radicalized, was actually contacting people about how he could commit attacks, including the Jewish kid in his school. The FBI found him. The family now is under constant surveillance by law enforcement. The kid has to live in a room where they have a locked door that at night, so that he can, they'll know if he leaves the room. There's actually a code to go into the room, a keypad to get in and out of the room for the family. And his mother one day went to cut up some onions in the kitchen, and all her kitchen knives were gone. Their son had borrowed them and hid them under his bed. This is what happens. And he went on the internet. He was radicalized in not just Islam, which is fine, but in radicalized Islam to commit violence. And now he's stealing kitchen knives from his family's kitchen and talking with people on the internet. So it's not so benign as lostgolfballs.com about what's going on. And we're talking about here is not the fact that there are videos and content on the website that the social media companies don't police as well as they could. that people can access if they know they do the right search. We're talking about recommendation algorithms, algorithms that push content that the person did not look for. This is from this particular article and report is about eating disorders, but it's not just about eating disorders, of course. And it's talking about the impact on youth, but this affects adults as well. Just as much. Youth are more impressionable, but given to people who are committing violent acts after being radicalized on the internet, it's not just kids. But here's what the recommendation algorithms do. They collect data, they predict and capture the user's attention, and they are optimized to collect attention and to keep people on the platform and engage in micro behaviors. From the same report, for minors, but I suggest not just for minors, these systems create predictable categories of harm. First of all, they present repeatedly violent and other content that were not sought out. It's not like you put a search into the search engine or on YouTube or whatever social media you're using. Yes, a video will show up. But what the problem isn't the video, it's the rapid progression of more videos recommended by the algorithm from general interest material to more extreme conduct and content, which has impacts on the user and their automated systems that select and promote content not from isolated posts, and it with design features and to increase time, et cetera, as noted in this report. That's recommendation algorithms. That's what we're here to talk about. I'm not here to talk about so much the fact that the videos are there and that the algorithms don't take them down. They don't do enough to police them. And we've, of course, gone through the politics of that in a couple of different cycles where people on the left were saying that there was misinformation and people on the right were saying they were taking down conservative content and slanting the information. We'll be talking about a few cases on that, but that's not the issue that I'm concerned about here. We're talking about recommendation algorithms that create violent acts in the real world. And what are we talking about? Why are we even discussing it? Because Section 230 of the Communications Decency Act provides immunity for social media companies for information provided by other information content providers. So the fact that there's a violent website or a dangerous website or whatever it might be on there that the people can find by doing an appropriate search is not the problem. It's not what Section 230 is talking. Well, it is what Section 230 is talking about. The fact that it's there doesn't make them the publisher of it. And that's what this statute was intended to protect them from because of the sheer volume. And again, as a person who lives in the intellectual property information technology world, as a lawyer, I understand that there's no way, no matter how good their algorithms and their systems are, that it can catch everything and police it on either direction. The questions for their liability are recommendation algorithms information provided by another information content provider? And are there any other defenses or obstacles to liability? We'll start this discussion with the Supreme Court case from a couple terms ago that actually did not reach the question. Everybody thought it was going to reach the question. It had been reached in the Ninth Circuit, which we'll be talking about in a moment. But the Supreme Court actually did not reach the question. It involved a claim brought by under JASTA, the Justice Against Sponsors of Terrorism Act, seeking recovery against social media companies for aiding and abetting persons committing international terrorism. In this particular case, the claim arose out of an ISIS attack in Turkey. Allegedly, the attackers had been radicalized by recommendation algorithms on social media. The Supreme Court found no liability for aiding and abetting in a unanimous decision because of the way the JASTA is written, and they were interpreting what aiding and abetting means. and which is not the topic of our discussion, but I'm pointing it out because the court never reached the Section 230 claim. And it's also interesting to note that the only claim the plaintiffs made in that case was a JASTA claim. They didn't include standard kind of tort theories that you might expect that we're starting to see in various contexts against social media, was not involved in the Supreme Court decision. And so think about what the court did not consider, even though it's going to be cited a lot. After all, the social media companies were found not liable for radicalized behavior arising out of their recommendation algorithms. But the reasons were, think about the things the court did not consider. So it is actually not precedent on these subjects. And this is where the court notes the volume. It was in the opinion. Every minute of the day, 500 hours of video are uploaded to YouTube. 1 billion hours of video are watched every day. 510,000 comments on Facebook, et cetera. The sheer volume of content. And that's why, for example, in my practice, when somebody wants to do a copyright DCA, Communication Decency Act takedown notice for a video, a pirated video of Star Trek on YouTube, it gets taken down, but it doesn't get, it can get put back up and they'll never know unless somebody else happens to flag it and does another request for takedown and another request for takedown. Because there's so much content, the algorithms can, no matter how good they are, can keep up. So in general, I agree with Section 230. The question is the application of it in this context to recommendation algorithms. And so we're going to talk about the Ninth Circuit case, because the Ninth Circuit case did reach the Section 230 issue. There were 3 cases in the case. Only one of them went up to the Supreme Court, Tomnet, but there were 3 cases from 3 different Ninth Circuit courts that were consolidated for appeal. The Tomnet case was involved in a terrorist attack in Turkey. The Gonzalez case involved a terrorist attack in Paris. And the Claiborne case involved one that you may all remember to some extent, one in San Bernardino, California. But they all arose out of the same thing. They were all ISIS-inspired attacks by people who had been radicalized by ISIS content through recommendation algorithms. Only one of them involved Section 230 assertions. And the court concluded that Section 230 did bar all of the claims, except one, interestingly enough. There was an allegation by Gonzalez that the algorithm or the business setup of YouTube shared revenue of the person who provided the video with the person who provided the video. And so that shared revenue could count as aiding and abetting, or at least it didn't fall within Section 230, but it was moot because the court, as did the Supreme Court later in the later opinion, in Tomnet, said that it didn't reach the aiding and abetting level to meet a JASTA claim. So even though Section 230 didn't bar the shared revenue claim, it barred all the rest of the claims, but it was moot because they didn't sufficiently plead aiding and abetting. This is what's interesting about this case and the next case we're going to talk about. There were 3 opinions from 3 judges, the majority, which is really just the main opinion, a concurrence by Judge Berzon, who we'll talk about again in a second, and a dissent by Judge Gould as to the Section 230 finding. Here's the majority opinion. Basically, he said that the recommendation algorithms match and suggest content to users based upon their viewing history, and it allows them to locate other videos and accounts related to ISIS. And that was the claim. That was the plaintiff's alleged. The court applied 2 tests to find that Google was not liable under Section 230, the material contribution test and the neutral tools test. Let me just talk about material contribution test. This is a Ninth Circuit doctrine. It's not necessarily adopted by all the circuits, but it certainly was the law in the Ninth Circuit. And other courts have used it, but it's not so well settled as in the Ninth Circuit. Material contribution means that the social media company, or in this case, the search engine, would have to have actually contributed to the content itself. And since there was no allegation that Google had actually helped make the videos be dangerous or have issues, that Google cannot be liable. And the neutral tools test said basically the algorithm doesn't make a difference. It could be looking for lost golf balls. It could be looking for videos on ducks. It could be videos on ISIS. It's a neutral tool. It applies the same across the board. It follows user behavior, recommends what the user might otherwise be interested in, has designs to keep the user interested and engaged on the platform. That's neutral, and therefore it wasn't enough to be the own conduct of Google, and therefore Google was not liable, and they affirmed dismissal. Remember, this case, not the Gonzalez case, but the Tabna case was the one that went to the Supreme Court. Judge Berzon's concurrence is fascinating because he agrees that Ninth Circuit precedent, particularly, there's three cases, but one is called, in particular, is called Deerwood, required dismissal under Section 230. But he then said that he disagrees with that precedent, and he thinks that it should be reversed and urged en banc review by the full Ninth Circuit. And his reasons were that he agreed with Judge Katzmann's dissent in a 2019 Second Circuit opinion in Force versus Facebook. Force, by the way, is Taylor Force, the family of Taylor Force, who was murdered in Jaffa, an American former soldier who was murdered in Jaffa, and is the reason that there is something in the U.S. called the Taylor Force Act, which you may or may not have heard of. I think many of the people on this call and on this presentation may have heard of the Taylor Force Act, but that's Taylor Force, which also the majority found, by the way, was no liability. But Judge Berzon said that if not bound by the precedent, he would have found liability. That he thinks that the term publisher reaches only traditional activities of publication and does not include recommendation algorithms. And therefore, he thinks that the prior precedent should be reconsidered and reversed. Judge Gould, in his dissent, agreed with Judge Berzon, but he didn't feel as constrained by prior precedent. He said that this conduct by Google falls outside of Section 230's immunity because it is not just information provided by another information provider. It is YouTube itself magnifying and amplifying it beyond what is done by considering them alone. And so it was their own conduct. And this quote from him is fascinating. It also tells you how it works in the technology. If a person asked YouTube to play a video showing one attack, others would be lined up and even start playing automatically. That's the problem. If the person didn't ask for those other videos, they might have looked for one. They might have been looking for it for another reason. They might have been looking for it so they could understand what's going on and be able to get involved in the process to stop it from happening further. But what happens is that they continue to get, that people who are otherwise inclined will continue to get content that they never asked for. And therefore, he concluded that Section 230 does not provide immunity for their own conduct because it goes beyond merely publishing the post and making it available. They were pushing the content itself on their own through their own drafted algorithm. What's fascinating is 2 of the 3 judges believe the Ninth Circuit precedent required dismissal of the case based on Section 230 immunity, but 2 of those, a different 2, one of them overlapping, obviously, believed that it was incorrect, and yet the court affirmed. And the Ninth Circuit never considered the matter en banc, as suggested by Judge Berzon, because the Supreme Court took Tabna. Everybody thought that if you'd read the literature, the legal press before, everybody thought the Supreme Court was going to take on Section 230, and they never did in the case because they didn't reach that question. They dealt with aiding and abetting under JASTA and never had to reach Section 230. And it's fascinating, just a month and a half ago, the Ninth Circuit in Doe versus Meta Platforms did the same thing. So nothing's changed. So this was from 2021, 5 years later, we're in 2026. Here's Doe versus Meta Platforms. In Doe versus Meta Platforms, the court again affirmed dismissal based on Section 230 immunity. This time, it's a really, to me, it's fascinating. All three judges agreed that immunity should not apply. Judge Berzon, again, the same Judge Berzon who concurred but said he thought the case was wrong, joined by the third judge in the panel, again concurred that on the main opinions for the same reason. Ninth Circuit opinion, I'm bound by it, I'm stuck, I think it's wrong, but it needs to be changed, but I can't change it myself. In a panel opinion, it needs to be en banc. Judge Nelson, who wrote the main opinion, what we might call the majority opinion, because all three judges concurred in it, he wrote his own separate concurrence to his own opinion. I've never seen that before, I have to say. And when he wrote it, he said, we have overread Section 230, straying from what the statutory text says, and we have expanded the word publisher, remember that's in the statute, to include what traditionally was never considered publishing. So all three judges, here's more on the main opinion. We agree that we have strayed from by immunizing algorithms. Moody, which we'll talk about in a second, Moody is a recent U.S. Supreme Court decision not involving Section 230, but he thought that personalized recommendations are the platform's own message. Remember, the statute says it has to be information provided by another person. But the recommendation algorithms are the own message of the platform, and therefore there should be no immunity. There's three judges on this panel. All three judges agreed that Section 230 did not apply, and all three judges voted to affirm dismissal based upon Section 230 immunity. That's a pretty rare occurrence, I would think. They all felt bound by prior precedent in the Ninth Circuit in April of 2026. So here's Moody. Moody is not a Section 230 case. Texas and Florida, I talked earlier about the politics issues involving whether the social media companies are not doing enough to get rid of misinformation. It came up especially during COVID, of course, but not only in COVID. And whether the social media companies are doing too much to censor conduct or content from those who think it should be out there. It did happen during COVID as well, in terms of the more conservative approach, viewpoint on whether it started in China, whether it didn't start in China, et cetera, but it goes on beyond that. So Texas and Florida, two red states, enacted statutes seeking to limit their ability in content moderation. It didn't have to do with recommendation algorithms now. The context, again, was with what I just talked about. I just mentioned that. So both applied to large social media platforms, both statutes. So they weren't dealing with smaller platforms, just the big people, where most people are getting access to their news feeds, their silos, as I refer to. And they restricted them from censoring or disfavoring posts based on content, source, or viewpoint. They required that the users provide notice if their content is to be removed or altered, and an explanation. Both statutes required that. NetChoice, which is a trade association, cited a First Amendment facial challenge that it didn't even have to go in the facts, and all of the opinions in this case really criticized the facial challenge aspect because no record had been created. But nonetheless, all the judges ruled for NetChoice, although for different reasons and with different consequences. Footnote 5, Justice Kagan wrote the majority opinion. This is what I'm saying. Moody does not apply, and yet it's being used for other reasons. We do not deal here with the feeds whose algorithms respond to how users act online, otherwise known as recommendation algorithms. The court specifically was saying that this case does not decide that question. But as we just saw, Justice Berzon, in his concurrence, referenced Moody. So I'm giving you Moody so you have context for why he was referencing it, and we'll see that again when we get to another case. And Justice Kagan all cites Justice Barrett's concurring opinion. Justice Barrett says that if the algorithm automatically presents to each user what they think the user will like, that might be a different answer. The First Amendment implications of Florida and Texas laws might be different for that kind of algorithm, which is the kind of algorithm that my talk is about. And so here's at least two judges, one saying we're not dealing with it, one saying we might be having a different answer if we were dealing with recommendation algorithms than what we're talking about today. I don't know why that's in higher font, but we'll deal with that. The third-party content whose feeds will display there are expressive choices, that is, the standards and guidelines of each of the social media companies, and the choices are giving them choices of how they're going to moderate content, and that is their expressive choice, which is not the same as a recommendation algorithm. And because that is true, they receive First Amendment protection. And this is from the Supreme Court decision, but it's basically explaining the history of at least the Texas statute, which is that the governor, those who passed and signed the statute were concerned about the social media companies silencing conservatives. Whether that they were really doing it or not is not the issue for the moment. The question is that's the issue that the legislatures were reaching for to try and make sure that there was a more balanced presentation. However, and the Supreme Court said that and nobody disagreed with this, by the way. This is a unanimous opinion, even though, or at least unanimous vote on the judgment, may not interfere with private actor speech to advance its own vision of ideological balance. If the First Amendment allows or prevents the government from tilting public's debate in a preferred direction. And I don't think that's a wrong decision necessarily on the law. Justice Alito had and with Thomas and Gorsuch had a concurrence, which basically said they only concurred in the judgment only because they didn't think the record was made. I can't remember, it was a facial challenge. But as to algorithms, they say that at this stage, we have no way of confirming whether they used algorithms to organize their content, much less whether the algorithms are expressive. Which, remember, that was the court's majority opinion by Justice Kagan, said that the content moderation was their own expressive content. The criticism there was that it wasn't enough to say whether it was expressive or not expressive. But it's still their own content. And then, of course, the question of who does the content moderation and the algorithms that prioritize content based on factors that even the platforms may not know and are not in the record. So, before we get to liability trends, we have at least 4 judges and maybe 5 on the Supreme Court, 3 in this concurrence and Justice Barrett in her separate concurrence, and maybe even Justice Kagan with her footnote 5, who are suggesting that recommendation algorithms may have a different result in the Supreme Court. But what are we seeing? Are we finding that there are beginning to be some cases involving liability findings against social media companies? And the answer is yes. Anderson versus TikTok, just a couple of years ago in the Third Circuit, involved the blackout challenge, in which on TikTok, in which people were having videos about how to choke themselves out, and her 10-year-old daughter hanged herself and died. Unlike the Tomna, Gonzalez, and Claiborne cases, it wasn't a claim based on a statute. It was basically claims for negligence and strict product liability, standard tort liability exposure, based upon the design of the product itself. And by the way, in these cases, the question of whether social media counts as a, quote, product, unquote, is also an issue. Most of the courts have been coming down on saying, yes, it's a product and it's subject to product liability. And certainly that's what happened in Anderson versus TikTok. The Third Circuit reversed dismissal. The district court had dismissed on 230 immunity. And this is why we talked about Moody, okay? In Moody, The Third Circuit said the court found, according to the Third Circuit, and I think they're right, that Section 230 immunizes only information provided by another. But here the information is TikTok's own expressive activity. The blackout challenge and the recommendation algorithms that pushed more and more videos of it that resulted in her daughter hanging herself fell outside of the Section 230 immunity because it was their own activity, their own conduct, their own speech. And to the extent that that speech was harmful, unreasonably dangerous, or negligently designed, the social media, in this case TikTok, could be found liable under negligence and strict product liability claims. There are cases out there, and one of them is the Ninth Circuit case, Deroff, that I mentioned, that the court itself in Anderson distinguished because they were pre-Moody. Green, Deroff, and Force. We just talked about Force. And so the interesting question is whether Moody, even though it's not itself a Section 230 case and not a recommended algorithm case, because it holds that the content moderation is their own expressive activity protected by the First Amendment, but where it's recommendation algorithms, it's their own conduct, but not necessarily expressive, whether that falls within Section 230. And this court said it does not, and it relied on Moody to find that. Here's another case from a few years earlier, but not that long ago, Lemon versus Snap, also Ninth Circuit, interestingly enough, in which the parents of boys killed in a high-speed one-car crash sued Snap for a negligent design of a feature for a smartphone app that encouraged them driving at high speeds. They were driving at over 100 miles an hour. They lost control of their car, and all three of the boys in the car were killed. The court again rejected Section 230 immunity because it was not based on their recovery, based on them as a publisher, but rather because on the app itself was unreasonably dangerous. And it did not involve information provided by another. You may have read in the last 2 months a couple of verdicts that have come down. One, in March of 2026, a Los Angeles jury in what is referred to as the KGM case. There are, I think, 1,600 cases pending, and they tried one as a bellwether case. Well, it says 440 similar, but one article I read, there might be 1,600 or so of these cases pending involving addiction, that social media companies have features, we talked about that, and recommendation algorithms are among them, designed to keep users using and on the platforms, and especially for youth, but not only for youth. And the theory was product liability, that the social media companies created these features, and it's the first case to go to trial and reach a jury verdict, and it would have $6 million judgment as to this one bellwether plaintiff. Then in the same month, the New Mexico Attorney General prevailed against Meta on the same concept, that is addiction, and $375 million in civil penalties. This is a jury trial, by the way. But it's interesting to note that we're talking about civil penalties because this was brought by the Attorney General, not by a plaintiff who was himself or herself damaged, based on consumer protection statutes, such as the Unfair Trade Practices Act, and as well as on a public nuisance. There's a three or four count complaint, and it's basically the New Mexico Attorney General seeking recovery on behalf of members of, citizens in the state based on consumer protection statutes, not product liability necessarily, but on unfair trade practices. The issue that comes up in these claims is proximate cause. Now remember that the plaintiffs in Anderson versus TikTok, and Lemon versus Snap, and in the addiction case, the KGM case, they were all the people who were addicted, or the families of the people who were addicted, like that family in that very first case where the 14-year-old son was radicalized. That person is the one that's damaged, and that person's family are the people who are directly injured by the conduct, the woman whose daughter hanged herself, et cetera. And so proximate cause is less of a problem in that case. But the terrorism radicalization claims involve arguably one more step, because the radicalized person isn't themselves injured. Arguably they are. They've changed their own lives, and a lot of times they are also injured or killed in the act. But they're inspired to injure other people. So there's an extra step involved. And so the question is whether proximate cause will apply if you're using a negligence or strict liability or other similar theory. And similarly, I suppose, for the consumer protection statutes. I'm not sure that it should have, that it makes a difference, but it's one that people who are going to be looking into this issue of liability of social media companies for their own conduct and recommendation algorithms will have to be considering. So is that an intervening cause in tort law? So we have Patterson versus Meta Platforms in New York Appellate Court in 2025, which goes against the trend that we've been seeing, but it kind of addresses the issues that we're talking about. So Patterson, you may have remembered this incident. A teenage shooter who became a white supremacist through radicalization online, at least that was the allegation, drove to Buffalo and opened fire at a grocery store at a predominantly black neighborhood, killing 10 people. He left a trail, right? He left a manifesto, et cetera, explaining why he did it, and he spent months planning the attack. They sued for negligence based upon recommendation algorithms, addicting the shooter and creating his radicalization, and that the platforms were designed to stimulate the very behavior that he eventually engaged in. The court ruled that the claim should be dismissed based upon Section 230. It disagreed with the TikTok versus Anderson case, the hanging case, because saying that there's no strict product liability exception to Section 230, and also found that the First Amendment granted its own protection, even if Section 230 did not apply. And this is where I get to the proximate cause, it also said that even if there was based merely on the shooter's addiction, they would fail on causation grounds, because the allegedly addictive features didn't necessarily cause the shooter to commit mass murder. Intervening criminal acts, it's not foreseeable. There's an interesting question, because they're deciding this on a motion to dismiss. Now, duty, tort law, negligence, duty, breach, proximate cause, and damage, right? Foreseeability is often a legal question, but to decide at this stage of the proceeding, which was on a motion to dismiss, yes, on appeal, that it's not foreseeable without any discovery and without any fact finding, strikes me as a little bit odd. I don't know that they don't really discuss the basis of that at all, especially given the literature that is out there, scientific literature that is beginning to be out there about the fact that it is very foreseeable, and we're seeing conduct after conduct and event after event of violence by people who have been radicalized through recommendation algorithms on social media. After all, in the addiction cases, the Los Angeles one and the New Mexico one, evidence was presented, for example, as to youth, of internal memoranda of Meta, if I remember correctly, about techniques that they could use to keep people on the platform and using it. So, to summarize, Section 230 was enacted to protect growth of social media because of the extreme volume, the millions of posts every minute, et cetera. And as an IP and IT lawyer, I don't disagree with that in general. I disagree with some of the application of it. Most, but not all of the courts are finding that the exception, that is, that it's not the information by a third party, but it's their own conduct, and therefore it falls outside of the Section 230 immunity. And I think we're going to continue to see developments as we go as to how far tort law and consumer protection theories should go, And it's these, you can see that even in the Ninth Circuit, we're going to see developments, I would think. Somebody's going to get that case up there en banc, or some panel is going to say, we've had enough chances at this. We're going to reverse. Okay, en banc, you tell us we were wrong. Or Supreme Court, you tell us we were wrong. But this is the direction I think it's going. And as to tort law, the battleground, I think, is going to end up being proximate cause, and whether that's a matter of law or a matter of fact. Given the persuasiveness of social media, and I think I'm going to change that word from, even though I wrote that word, to pervasiveness as well as persuasiveness, and framing the ideas and the potential uses by bad actors, I think people considering public policy should be evaluating how we're going to address accountability for this. Because again, this is their own conduct. We are not talking about the fact that the posts were there and it could be found through an appropriate search. We're talking about push technology, drafted and created by the social media companies themselves, their own conduct. That is not the same thing, and that is not what Section 230 was intended to prevent. And so I think we're going to continue to see continued exploration of these boundaries. And after all, Section 230 was drafted by the legislature, and it can be repealed or amended if we're seeing that public policy is, and just the way things are going, and polarization and hate speech and everything else that is happening on social media, maximized, pushed by social media algorithms, is going to be an issue. So with that, I will leave it open 15 minutes or so we have left for questions if we have any. Aviva, I will leave it to you.
Yeah, we have none in the chat, but it was a lot to take in, so maybe people are synthesizing it all now. I'm sorry, let me turn my mic here. So if people want to put it in chat, or if you just want to raise your hand, and we can call on you, although I won't be able to see raised hands while the PowerPoint is up. So let me see if I can. Well, while we're waiting for other people to ask questions, I have one, and that is there a bill now in Congress to amend Section 230?
I'm not aware of one.
Okay.
And I don't know that whether it would pass. What's fascinating from the political standpoint is, again, it's sort of what happened with Texas and Florida. The polarization of America and the inability of anybody to talk to each other about legislation probably means that the same issue about misinformation versus censoring will continue to be, and I don't know that they'll ever be able to agree on anything. But they agreed on Section 230 in the first place at the infancy of the internet. I saw a couple of questions that came up, but I didn't. They popped back out.
Okay,
So
I'll go in there and take a look at that. Okay, so Jonathan says, for a while there was an argument mostly from conservatives that editorial discretion, for example, to censor, abrogated Section 230. And he's asking whether, well, he says he was never convinced by it, and he wants to know whether the courts have weighed in on it.
Well, to the extent that the courts have weighed in it, the courts have weighed in it, saying that it is, that if you're exercising traditional publication and editorial behaviors, deciding what to publish and what not to publish. You know, you send a letter to the editor, you submit an op-ed to your local newspaper. They decide what to publish. They don't have to. You don't have to take it. If you're sending something in and it gets edited, if you have in the normal opinion columns or their regular news feeds, they decide what to publish and what not. If you're doing that, that is likely going to fall within Section 230, because it's information provided by another, and it's there, and it's pure. Remember what the statute says. It says will not be treated as a publisher or the speaker for information provided by others. So if it's information, and so if you're exercising traditional publisher discretion, I think the courts are going to continue to say that there's no liability under Section 230 unless it gets amended.
Thank you. And Ryan has a question.
Before that, we have a question here in the room. Go ahead.
Okay.
Say if the Ninth Circuit says that the like algorithm is not protected by CDA, how would the argument of undue burden, having to monitor every speech out there that might be harmful, how would that?
Well, I don't think it affects it because again, if the amount of content is such that they can't monitor it. I don't care how good their algorithms get, they can't do it. But this is not about that. It doesn't impact that because this is about push technology. It's not that the content is there to be found if someone puts the right search question in. It's the fact that they push it to people who didn't ask for it. Just like I didn't ask lostgolfballs.com to put an ad on my Times of Israel or my Wall Street Journal or my New York Times page. It just popped.
Right.
Okay. So the issue, and again, that's a benign example, even if it's annoying, right? It doesn't keep me from buying lostgolfballs.com. But nonetheless, I didn't go to, some other used golf ball site because of the ads, although I might someday if they keep doing it. But that's benign. But it's not about that. It's about the fact that it's pushed to people who didn't ask. And it's designed to do that. And that creates more and more extreme content that keeps showing. It doesn't just the same content. It pushes more extreme content because once you're on the one, then it leads you to the next one, which leads you to 3 more, and each one more extreme than the other. Let me get one online, and then Pete, we'll go back to you. Go ahead.
Yeah, Brian is asking if 230 is repealed, what would be elements to prove negligence?
Same as any other kind of negligence case. A duty to design a product that is reasonably safe. The standard of care, right? What would a reasonable person who's being reasonably safe what would a reasonable person do under the circumstances, or a reasonable person not do under the circumstances? First, there has to be a duty. There's always a duty to not act in a dangerous manner and to design things negligently. And those of us who grew up doing product liability law, I may do IP now, but I grew up doing tort law and product liability. It's the same as any other kind of product. The duty to not design, you can have strict liability in tort, but you can also have negligence. Duty does not design a car that has the gas tank in the center where it's going to explode when rear-ended. So it's the same as any other. So duty, breach, and scope of duty is a legal question, of course. Proximate cause and damage. That's the same for any other kind of negligence case. And in strict liability, there's 2 standards for strict liability. One is unreasonably dangerous, but the restatement has there's 2 different standards. One is the risk utility test. I'm not going to get into too much detail on the on the restatement of torts. Second on product liability, but the risk utility test and then the consumer expectation test are the 2 standards for strict liability and tort. Peter.
Yes, I have a question about the algorithm issue. So I don't really understand it fully, but is that sort of like if I go on the internet and I'm into coin collecting and I'm looking for coins, and all of a sudden I'm getting all this coin options being put in front of me. So when you go,
by the way, that's the neutral tool piece, right? Because if you're doing coin collection and you're getting more coin collection stuff, that sounds benign. That's the neutral tool, right? The same algorithm does that as well as pushing ISIS videos.
So when I first started doing that, I was thinking, wow, I'm surprised how coin collecting is becoming so popular, right? I didn't realize it was connected to me personally, but I picked up on that.
The troglodytes in the room.
But with respect to social media, is there like a way you can sort of turn that off where somebody can go on and say, I'm doing the search, but I don't want to have it pushed back.
I don't know. I say this all the time. I live in the intellectual property and information technology space, but I'm an English major. I'm not personally a technologist, and I haven't had reason to look into.
Because if they put that option up there and you could click one way or maybe that would be something, but it still wouldn't stop this problem with kids going on there and having.
Well, it's beyond that. The way they, when we're going to run out of time, I guess, if I keep on telling stories. But I was doing this long enough ago where there was the whole question of people were doing seed money and angel funding and all this. and I kept on asking all these developers in the early stages of internet, how are you making money? How are you monetizing this? I never could figure out when Google first came out how they were going to make any money
Yeah,
because it was free,
right.
right? Nobody, but the way they monetized it was by the ads and et cetera. And so I doubt that they're going to encourage people to be able to have that feature. Now, whether they really have it or not, I haven't checked, in fairness. But that's the way they make the money that they make, is the monetizing of the people who, and that's why they're encouraging people to stay on the platform and addicting people, et cetera, et cetera.
And then that radicalizes them depending on the content.
Right.
And then
Well, it's at least enough people, you know, it only has to radicalize a few out of the millions. Okay,
Yes, I can radicalize.
Aviva, next online.
Yeah, we have a question from Avi. He wants to know, isn't manipulation of the algorithm in terms of what is being seen by users and what is not, acting as a publisher and not just as a platform?
My view is no, because there's no decision, except I guess you could argue, and certainly the media companies do argue, that the algorithm, whoever created the algorithm was creating it so it would do content moderation automatically. I guess you could say that. But it's not really moderating content, right? It's not saying this should be seen or this shouldn't be seen. This should be available, this should be taken down or not taken down, right? It's pushing content that the user didn't ask for. The publication is making the video available online. Having to, you know, somebody uploads it, it's there to be found. That's publication, same as your newspaper, right? You publish the newspaper, somebody can go buy it and read it, or take it online or whatever. They can read it. That's the publication. But if you get a newspaper, it's not pushing additional content to you that you didn't ask for. You have to go get it. So I would argue, and certainly the courts so far have agreed with this argument, that it is not merely publication when you are suggesting content that the user didn't ask for. Now, the user doesn't have to click on it, but because of the addictive features of the product, people tend to do that. I expect that many people on this presentation have experienced that personally. Go ahead, Aviva, next one.
Hey, Edward asks, to what extent, if any, might restrictions and penalties imposed by other countries possibly curtail social media publication, even if Section 230 remains in place?
I'll have to say I don't know for sure. Obviously, look, we experience it in the U.S. where California rules the United States by deciding whatever consumer protection law they want, and then everybody has to follow because nobody's going to have a California-only designed car, or whatever. Part of my practice involves privacy law, and when the California Consumer Privacy Act came out, everybody had to start complying, even though because if you were not in California, but you had some California users, you weren't going to have a separate website just for California. Although I did have some clients who said, we are not going, if this is what we're going to have to do, we are not going to interact with people in California. And they had a pop-up on their website which said, if you're from California, please advise, and we won't have access. I had a few clients who did that, at least at the beginning, but now all these states are passing. And then, of course, California CCPA started with the European Union's GDPR, General Data Privacy Regulations, which California then did one up on with different versions, different things. So Europe started controlling what the US did. And so of course, there's interaction. And of course, the social media companies are going to do their best to comply without getting fined for billions of dollars in the EU. Having said that, it's not quite the same because they do know where you're from when you're using an internet interfacing with the website, right? It has your ID address, it has your IP address, et cetera. The social media algorithms know where you're from, and so they could very well have different content. We're going to go call it content moderation, different algorithms that apply. After all, the entire question of recommendation algorithms is individually based search history. What you like, what you yourself like to look at. I like to watch a lot of comedians, and so I see a lot of comics come up on my Facebook page. Look at Don McMillan one time. He's really great. That's my ad for the day. But He's an engineer comic who works in Facebook, works in PowerPoint. You've never seen a comic work in Facebook, in PowerPoint before. He's hilarious. So in any event, that's what comes up in mind. And so I would expect that the fact that other countries are able to restrict it without our Section 230 and without, even though they have free speech rules, they're not quite as robust as our First Amendment protections. Will not make the big difference on how the algorithms are working in the US, but I don't know that for sure.
We have another one that is posed. I'm not sure whether it's a comment or a question, so I'll try to put it in a question.
Okay.
Whether
Thank you, Ms. Jeopardy.
if we're talking about a First Amendment argument that's restricting freedom of speech, or is this really about trying to restrict incitement online?
Well, the question of First Amendment and this kind of speech is one that I have dealt with separately, and my videos for Decalogue Society are on the Decalogue page website, YouTube page actually. Not push content, you have to go find it, however. And so if you're interested in what I've had to say about hate speech, whether it is or is not protected by First Amendment and how we decide what counts as hate speech, there's 2 one-hour-long videos from me on Decalogue's website that discuss that. People may disagree with me on that. That's cool, but at least that's where but my view is that hate speech, which is what we're talking about in the ISIS context that was the subject of Tamna and Gonzalez, for example, and other similar kind of speech that encourages violence, radicalizes towards violence, is not protected by the First Amendment. And there is no case that has said so, actually. And so I would say that a bill, an act or case law that says that there is liability for recommendation algorithms that push dangerous content is not a First Amendment violation, and is not affecting free speech anyway. By the way, we regulate speech in all sorts of ways. Again, I don't want to go through the whole video that I spent two one-hour videos here, but we regulate speech all the time. In my practice of intellectual property law, copyright and trademark are, after all, speech, and they're heavily regulated by statute with severe consequences for infringement.
Okay, the rest of the posts all seem to be a conversation between a couple of our.
Okay, well, I don't have access to that, so I can't really.
Yeah, I know, but they're not posing questions. I think they're debating each other. But
Okay.
is that wrong? If Jonathan or Thomas, anyone else in this one has an actual question, or Brian, if you want to unmute yourself and ask it.
I had a question. How would this differ than like the restrictions around cigarettes? Like,
there's an article, I have it here, from the Wall Street Journal, an opinion op-ed not by the editorial board of Wall Street Journal, but they published it, that suggested that social media should be treated like cigarettes. I'm not sure whether he's right or wrong, and I've never, let me even back up. As a person who grew up doing product liability, I was never in favor of product liability being the engine of social change, right? I'm very much an anti-gun person personally, and I've written articles, in fact, in my time as a visual blog. I've got at least 2 or 3 of them on the Supreme Court rulings on what is or is not protected for gun control. But I don't think product liability law was the way to solve that. Legislatures should solve that. In this instance, however, yes, it would be great if legislatures would solve it, but I think that tort law does apply because the product itself is dangerous, whereas the gun is not necessarily dangerous in and of itself. This product is, because it's radicalizing people, and it's created to do that. At least that's my opinion, for what it's worth. I mean, just love its opinion, so we can take that for what it's worth.
you're my echo chamber, so it's okay.
Okay.
Well, we have like 1 more minute if someone has a quick question. If not, I think that we will wrap it up.
Hey, this is Brian Mahoney. David, first of all, thanks for a great presentation.
Thank you,
A
Brian.
quick question for you, though. If there's an extreme example where the media company says, we don't have any algorithm that starts, we take your first 1,000 things you click on, and you can click on anything you want, and then it's just pure mathematics. Based on what you click on, we feed you virtually identical things, just different iterations of it. To me, that seems far afield from publishing, because there doesn't seem to be any discretion or any content creation whatsoever. That's literally just applying a mathematical formula that the user sets the first parameters on, and then it just follows that. Am I
Well,
missing something?
All an algorithm is a mathematical formula. Okay, I mean, computer code is mathematical formula. It's a set of instructions. What you've just described is not a mathematical formula. It's actually a set of instructions, right? That's exactly what an algorithm does. It's a set of instructions. If this, then that. That's very binary, and of course we've moved way beyond that now in the technology today. But that what you've just described is the very thing that is an algorithm, and the content is picked by the algorithm to be pushed.
Okay.
I got done in an hour. I'm very proud of myself.
Thank you very much, David, for a great presentation. Lots and lots of content there, as your presentations always are. I want to thank everyone for attending. I'm going to start the poll now and ask you to take the evaluation poll for those of you who are online. And
So